morning. Thank you very much for joining us for the second European Law interview. We are still in the first series devoted to the internal market and environmental measures. This program is sponsored by the Monnet Chair, which is promoting innovating learning processes and is part of the European Commission Learning and Educative program. This second interview is very important. We will have the great opportunity to interview Professor Nicolas de Sadeleer. He is a professor in EU law and environmental law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good morning, Professor.
Hello.
Thank you very much for joining us. This second interview today will be focusing on Article 34 and 35 of the TFEU. So, in the absence of harmonization through directives or regulations, or in case of incomplete harmonization, we still have to use provisions of the TFEU establishing the free movement of goods and services. So I'm referring to Article 28, Article 30, Article 34, Article 35 and Article 110 for goods, and then for services I'm referring to Article 56 TFEU. So we saw earlier that we can have fiscal and non-fiscal barriers to free movement of goods, and we do not have only direct barriers. We also have, for example, charges equivalent to those barriers and quantitative restrictions. So it's very important to implement the principle of free movement of goods within the EU legal order. However, there are lots of possible provisions and legal bases for actions, and it's very important to identify the right one. It's important to assess national measures on the basis of the right legal provision. Sometimes we have hybrid national measures combining, for example, taxation technical aspects, and the practitioner has to be very careful and be sure that he uses the right legal basis. So today we will discuss Article 34 and Article 35. I'm going to read those provisions to make sure that you remember what it is about. So first of all, Article 34, so it reads, quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. Article 35 is quite similar. It reads, quantitative restrictions on exports and all measures having equivalent effect shall be prohibited between member states. Today we will focus on Article 34 because another interview is devoted to Article 35. Okay, Professor, let's start with the first question. Is there a risk that national measures and national policies hinder Article 34?
Yes, there is a suite of examples. I'll give you but a few ones. Regarding the Belgian legislations on keeping wild animals, such as a fox or a wolf, the Belgian authorities have been laying down a restrictive positive list. So animals, wild mammals that can be marketed or be kept at home are the ones listed in a national decree. The Commission has been contending with that list, and the Commission lodged a lawsuit against Belgium before the Court of Justice, an infringement action. The Court of Justice ruled on the case in deciding that the positive list adopted by the Belgian authority was a measure having equivalent effect to quantitative restrictions for the purpose of Article 30. Another good case in point is the decision adopted by the Austrian authorities to ban some categories of trucks in riding on a motorway in the Inn Valley in Austria. Many truck drivers do circumvent Switzerland to move their goods from Germany to Italy or from Italy to Germany, and in so doing they do cross the Inn Valley in Austria. Given that the Austrian authorities are unable to meet the air quality targets laid down in different EU directives, they decided a few years ago to ban the use of the motor highway by a number of specific trucks. That limitation has been challenged by the European Commission before the Court of Justice. Again, the Court of Justice classified the ban as a measure having equivalent effects. Third illustration, well, that would be the obligation in Germany to reuse a significant amount of water bottle packaging in order to avoid discarding household waste or to recycle these bottles, given that it has an impact on the bottles being marketed, the foreign bottles being marketed in Germany, such as the bottles produced by Sparren in Belgium or San Pellegrino in Italy, or Vittel in France, or Vichy in France. Well, the Court of Justice took the view that such an obligation was tantamount to a measure having equivalent effects.
Okay, thank you very much. It's much more clearer now. And I have only one small question then. So, do you think that Article 34 is very difficult to understand because it's very concise?
Yes, the conciseness of the provision belies the complexity of the scope of application, given that the treaty drafters never gave any guidance as to how to interpret the concept of import or export or measures having equivalent effect. Mm-hmm. The Court of Justice was called on since the 1960s to fill the gap in determining the scope of each of these concepts. So the lawyers in Europe have indeed to pay heed to the 60 years of Court of Justice case law.
Okay, so this is due to the fact that there is no definition at all in the treaty. So we have to focus all the time on the case law of the Court of Justice and possible and potential evolutions.
Yeah, and that's perhaps rather complex for lawyers specialized in consumer law or in foodstuff or in environmental issues. They don't necessarily grapple with all the complexity of 60 years of case law on the free movement of goods, where the court has been adjudicating cases ranging from grapefruits to motor vehicles.
Okay. We will now focus on the real scope of application of Article 34. If you don't mind, we will start with the personal scope of application. So, can you please tell me which national authorities have to comply with Article 34?
Well, of importance is to note that Article 34, as well as Article 35, target national authorities. As a matter of law, individuals are excluded. Given that the environmental policy is usually decentralized, so the powers have been conferred in a number of member states on the regions or on the provinces and so on, a myriad of national authorities do apply EU measures, but accordingly they also do have to take into consideration, whenever they are carving out the local or the regional measures, Article 34 or Article 35. So, for instance, a commune, a municipality is called on to abide by the principle of the movement of goods as well as a member state. That being said, it must be noted also that bodies vested with quasi-regulatory powers or de facto regulatory powers are also called on to abide by the free movement of goods principle. For instance, Frabo, a German company, private company, but vested with specific regulatory powers regarding certification of a water product, was judged to be an authority in the broad sense, and thus the decisions adopted by that body had to be consistent with Article 34 of the treaty.
Okay, thank you very much. And then it's pretty clear for national authorities, but what about EU institutions? Do they have to comply with Article 34?
Well, EU institutions have to abide to Article 34, but to a lesser extent than the national authorities. That means that EU institutions, through their regulations and directive, cannot enable the member states to enact national measures that would be in breach of Article 34. What is more, the obligations laid down in the directives and the regulations have to be interpreted in the light of Article 34.
Can you please give me an example?
Well, safety high-tech would be a good case in point. Safety high-tech dealt with an EU regulations that was restricting the placing on the market of depleting substances. So the Italian lawyers argued before the Court of Justice that in banning such substances, the regulation was tantamount to a measure hindering free trade within the EU. The Court of Justice concurred with that argument and so recognized that Article 34 was applicable to the regulation. However, the Court of Justice stressed that there were genuine environmental justification leading the EU institutions to restrict the trade in ozone-depleting substances.
Okay, and at the end of the day, what is the room of maneuver left to EU institutions then?
Well, the room of maneuver left to the institution is much broader than the one left to the member states. Member states authorities have to comply with the principle of the free movement of goods. Whenever the harmonization has been complete, they have to abide by the standards laid down under the regulation or the directive. When there is no positive harmonization, they will have to comply quite strictly with either Article 30 or Article 34, 35. So the Court of Justice is endorsing a rather strict approach toward the member states. On the contrary, regarding the EU institution, the Court of Justice is likely to endorse a much more marginal review of their actions. Why? On the mere fact that whenever the EU institutions regulate product, they do it for the whole internal market. So the measure is not unilateral, it's not decided at national level, but it's decided for all the European Union. And accordingly, the EU measures benefit a legitimacy in the light of Article 34 or 35.
Okay, so it's much more clear for EU institutions and national authorities. What about individuals?
Well, the individuals are not falling within the personal scope of ambit of Article 34 or Article 35. These provisions do target state authorities or decentralized authorities. Private bodies vested with specific regulatory or de facto regulatory powers are likely to fall within the personal scope of ambit, but this is rather exceptional, as I stressed a few minutes ago.
Okay, and can you then explain this very important notion of horizontal effect?
Well, horizontal effect means that it would be possible for an individual to claim that Article 34 has been infringed by another individual before a national court. The vertical dimension of Article 34 or Article 35 precludes horizontal direct effect. So a trader can invoke either Article 34 or Article 35 against a public authority, but not against a private company.
Okay, thank you very much. I would like to move on to a much more current phenomenon. So we see every day things like buy local, be loyal, and buy local campaigns everywhere. So those campaigns basically promote the fact that people buy local products instead of products coming from much further away. So this might potentially hinder the import of goods coming from other member states. And my question is, consequently, are these campaigns or even boycotts consistent with Article 34?
Well, in brief, inasmuch as the campaign or the boycott has not been promoted by state authorities or has not been financed by the government, such boycotts, such campaign are falling out with the scope of ambit of Article 34. So importers cannot contend with the campaigners that they do infringe Article 34. As I stressed, Article 34 or even Article 35 just have vertical direct effect. By no means these provisions have an horizontal direct effect.
Okay, and then if I understand you well, environmental policies are very broad. They may cover issues like renewable energy, wildlife conservation, cleaner products, chemicals, and yeah, a lot of these. And so are all these substances and objects falling within the scope of Article 34 and 35?
Well, whenever these objects are deemed to be goods, they are falling within the scope of ambit of these provisions. So be it a duck or a geese, not in the sky, but likely to be marketed, these animals are deemed to be goods. Okay,
thank you. And then can you please tell me what is a good? Is there a definition?
Well, no, indeed, nowhere in the treaty is the concept of good defined. Secondly, the treaty drafters have been using the concepts of export and import instead of goods. Thirdly, the Court of Justice filled the gap in defining goods as all objects taken across a frontier for the purpose of a commercial transaction, whatever the nature of that transaction. As a result, wild animals that are caught, such as birds, parrots, raptors, frogs, mammals, plants, are deemed to be goods on the grounds that they are likely to be taken across a frontier for the purpose of being traded. By the same token, the Court of Justice has been taking the view that electricity is deemed to be a good for the purpose of Article 34.
Okay, and then what about waste? Is it also falling within this goods category?
Well, one is really dealing with a huge amount of categories of waste, ranging from household waste to hazardous waste, to nuclear waste. So it's difficult to say, okay, one is dealing just with one category of waste. There's been a discussion before the Court of Justice whether non-recyclable, non-marketable waste was still deemed to be a good for the purpose of Article 34. In a case opposing the European Commission against Belgium for the banning of landfilling foreign waste in the territory of the Walloon region, the Walloon, or the Belgian authorities and the Walloon government were arguing that non-recyclable waste was falling out with the scope of ambit of the aforesaid definition on the ground that there were no more commercial transactions. The Court of Justice has been dismissing that argument in its judgments that was handed down on the 9th of July 1992. and if I may, I will read the paragraph. The court explained that the distinction between recyclable and non-recyclable waste is particularly difficult to apply in practice, especially with respect to controls at frontiers, liable to change in the course of time according to technical progress. And the Court of Justice concluded that waste, whether recyclable or not, had to be regarded as goods, the movement of which, in accordance with Article 34, must, in principle, not be prevented.
Okay, so in principle, provisions on free movement of goods apply only if the contested national measure impedes interstate trade. Can the application of Article 34 be excluded on the sole ground that all elements of the case are limited to the borders of a member state, so it's within one member state?
It's a really awkward question, if I may say. As a matter of principle, a local situation where there is no external foreign elements are not encompassed within the scope of ambit of such a provision. That being said, the Court of Justice ruled on different local measures and concluded that these measures were quantitative measures having equivalent effect to quantitative restrictions. The Bloom case is of interest in that connection. Bloom was about importing in Denmark beehives from continental Denmark on the island of Læsø. And so though the beehives were not coming neither from Germany nor from Netherlands or from England, nonetheless, the Court of Justice concluded that Article 34 was applicable to the transfer of these beehives from continental Denmark to the island of Læsø. Another good case in point is the prohibition of exporting municipal building waste from Copenhagen city to outside Copenhagen. The Court of Justice took the view that Article 35 applied to that situation on the account that such a prohibition was also applying to possible export from Denmark to Sweden, for instance.
Okay, so there is no de minimis rule.
Well, there is no de minimis rule. As a matter of fact, the Court of Justice has been rejecting any possibility to apply de minimis rule. So whatever the value of the object, the value of the pheasant, or the value of the ruddy, or the value of the mallard, Article 34 or Article 35 apply. So some litigations relate to insignificant, from an economic perspective, matters. Whereas other litigation are likely to concern huge trade flows. So, yes, the Court of Justice is keen in rejecting a de minimis approach. And regarding the territorial scope, the Court of Justice is ready to review rather local measures, considering that there is the possibility of external elements.
Okay, thank you very much. So that was about the territorial scope of ambit of Article 34. We'll now go back to a notion you just mentioned, MEEs, so measures having equivalent effect to quantitative restrictions. It's very unlikely to meet and face concrete quantitative restrictions. That's why the EU created the notion of MEE, and it's not very clear, it's not defined in the treaty, so we have to look at the case law again and again. And the Court of Justice basically expanded the scope and the definition of this notion. So the very first important case is the Dassenville judgment. I'm going to read the important paragraph, if you don't mind, and then we will discuss cases further on, okay? So the important paragraph says that all trading rules enacted by member states which are capable of hindering directly or indirectly actually or potentially intra-community trade are to be considered as measures having an effect equivalent to quantitative restrictions. How is this judgment, so the Dassenville judgment, relevant for environmental measures?
First and foremost, one is struck by the sheer breadth of the formula. According to the case law, it's possible that Article 34 covers any kind of national measures that's likely to hinder free movement of goods directly or potentially. In so doing, the Court of Justice has been maximizing the traders' rights. Traders have been able, ever since, to challenge any kind of national measures likely to impinge upon their imports. The breadth of the formula has been so extensive that the Court of Justice in 1991 was obliged to curtail it in the Keken Mitra judgment that we will discuss later on. Of importance is to note that in the formula the terms all trading rules are related to the marketing of the products. That means that the production stage does escape Article 34. Kramer is a good case in point in that connection. In Kramer, the litigant challenged national English rules limiting fish production. The Court of Justice took the view that was not dealing with the marketing of the fish, but the national measure dealt with the production stage. Other terms are of interest. The formula is stressing trading rules enacted by member states. As we discussed earlier, some bodies, private bodies vested with quasi-regulated powers are likely to fall within the scope of ambit of that provision. But of utmost interest are the adjectives directly, indirectly, actually, and potentially. And these are the most important elements of the formula. In inserting these four adjectives, the Court of Justice emphasized an effect-based approach to the detriment to a mere protectionist approach. So of importance is to determine the effect entailed by the national measure rather than the nature of the measure or the intention of the national authorities adopting the challenged measure.
Okay, thank you very much. So Dassenville was the first very important judgment. Then the court introduced another criterion called discrimination. It was in Cassis de Dijon case. And there the court said that all measures with an impact on intra-community trade, if they are discriminatory, will be caught under Article 34 TFEU. I'm going to read the right excerpts of the judgment, if you don't mind, and then ask you to comment. So the relevant excerpt in Cassis de Dijon case reads as follows. MEEs encompass measures that are applicable without distinction to foreign and domestic goods, as a foreign producer may find it more difficult to respect these rules than a national producer. What is the added value of this Cassis de Dijon case, basically?
Well, before Cassis de Dijon, one was drawing a distinction between distinctly applicable and indistinctly applicable measure. A few words of explanation, if I may.
Of course.
Distinctly applicable measures are tantamount to discriminatory measures. The foreign products is treated less favorably when it should be treated the same way than a domestic product. Discrimination is clear on the face of the measure. In sharp contrast, indistinctly applicable measures do apply
to both domestic and foreign products. But they do de facto differentiate these two categories of products in placing a higher burden on the foreign products. Indistinctly applicable measures entail, consequently, a double burden for the importers. The importer must comply with its own national standards. In addition, he is called on to comply also with the home state standards. So one is speaking of a double burden. So the added value of Cassis de Dijon is to get rid of the double standards in proclaiming this principle of mutual recognition. A single standard should apply the standard of the state in which the good has been produced.
Can you please further explain this notion of mutual recognition?
Mutual recognition is a principle whereby the sale of goods that are lawfully produced or marketed in a member state cannot be restricted in another member state without good cause. Well, let's imagine the situation of a German producer of sausages. Okay. He will have to comply with the food safety German standards, whenever these standards are not EU or harmonized. Whenever he's envisioning to sell his sausages abroad in Belgium or in France, is not obliged to comply with either the French or the Belgian standard. So he's escaping the double burden.
Okay, thank you. Then let's move on to something else. What about measures having no significant impact on imports? Do they run counter Article 34?
No. Even measures with slight impacts, potential impacts, are likely to fall within the scope of ambit of Article 34. That's why, thanks to Dassonville versus Procureur du Roi, the scope of that provision is so broad.
Okay, thank you. And what about the Bloom judgment? Is it relevant here?
Well, the Bloom was about this import on the island of Leso in Denmark of these beehives that were on Danish continental territory. So though the impact was extremely limited, it was a case with but a few beehives whose economic values, I imagine, was not very important. Nonetheless, the Court of Justice ruled on the case in the light of Article 34. So Article 34 applied to just but a few beehives that could not be imported on the island of Leysen.
Okay, and then can Article 34 be excluded on the sole ground that there is no competing production on the territory of the importing member state?
This is a very relevant question. Let's imagine that state authorities are keen in protecting other categories of products that are produced at home. They might still be interested to hinder the import of products that are likely to compete with the national products, though they are not similar. So the absence of similarity between the products does not preclude the application of Article 34.
Okay, thank you very much. And the last question, do you think that we should consider statistical evidence while assessing the volumes of goods affected?
Well, I cannot decide for the Court of Justice so far, but the Court of Justice embraces a rather theoretical, hypothetical approach of the impacts. I imagine for the importers or the exporters or the European Commission challenging national measures, it's an added value to come with clear statistics demonstrating that the trade in goods in particular good has been hindered. But in the court view, this is not necessary. The court can embark upon an hypothetical analysis of the impact on the trade flow.
Thank you very much, Professor. So this is the end of our second European law interview on trade versus the environment. So today we discussed Article 34 TFEU. So we basically dealt with the scope of this provision, starting with the personal scope. So we saw that it applies to national authorities and even sometimes national companies. Then we saw that it applies to EU institutions, but not to individuals, and to the current issue of small local, buy local campaigns. After that, we discussed the material scope of the provision. So it applies to goods basically, and we gave a definition of this notion. Finally, we saw the territorial scope and discussed case law application with mainly the Dassonville and Cassis de Dijon case. Thank you very much for watching us. We will see you next week for other interviews, and mainly one on Article 35 TFEU. If you are looking for more information on the topic, you might consult Professor de Sadeleer's book, published by Oxford University Press, on trade versus the environment. Thank you very much. See you next week.